love me my hats.
The meeting of the Public Safety Committee is now called to order. Mr. Clerk, would you please call the roll?
Alderman Bosley. Alderman French. Alderman Vaquero.
Present.
Alderman Cohn.
Present.
Alderman Carter. Alderman Coter. Alderwoman Spencer.
Here.
Alderwoman Green.
Present.
Chairman Kennedy.
Here.
We have 5 present and we have a quorum.
Thank you, Mr. Clerk. Last week we had the opportunity of hearing from the chief related to the policies for the use of the body cams. Thought it would also be good to hear from the public today, particularly those groups and organizations that have been working around this issue. So we invited here today representatives from Drone Free St. Louis as well as the ACLU of Missouri to talk about their thoughts and ideas related to the city's policy in relationship to body cams. We have 4 individuals who will be speaking today, Mr. Jeffrey Mittman, Kayla Reed, John Chasnoff, and Rachel Kent. We will first start off with Jeffrey Mittman, who's with the ACLU of Missouri, who will be discussing the use of body cams and civil liberties.
Mr. Chairman.
First, I'd like to thank you for coming and all the others who are here today and taking the time out to testify before the committee.
Great, thank you so much. My name is Jeffrey Mittman. I'm the Executive Director of the ACLU of Missouri. Mr. Chair, members of the committee, thank you for the opportunity to speak to you today. What I wanted to do briefly is give you a general oversight of the ACLU's orientation on this issue. Our job is to protect the civil liberties and constitutional rights of all Missourians, guaranteed under the U.S. and Missouri constitutions. Body cams are a unique technological tool in that they impact several civil liberties and constitutional rights. Our general approach to tools and technology is, in and of themselves, they are neither good nor bad. It is how we use them, how we regulate them, and how we manage the balance of safety and security. Some of the issues that we see with respect to body cameras, generally, we are in favor of them as a tool. Why is that? We know that in the current climate, many police issues can arise. Body cams provide a balancing mechanism. We know that many police officers have a commitment to public service. They go about their jobs in ways that are intended to promote public safety and protect and serve the public. For those officers who are conducting their affairs in that manner, a body cam is a record that shows that they are doing their job properly. By the same token, we know, unfortunately, there are a few bad apples. For those bad apples, a body cam does one of 2 things. Either it makes them put their behavior in accordance with proper procedures and policies, or when they do not conduct themselves appropriately, there is documented evidence that can be used to protect the public. That being said, what are the other constitutional rights and civil liberties issues that come up? 1, there's a matter of government transparency, and 2, there's a matter of individual privacy. With respect to government transparency, as you are well aware, the state of Missouri has a very strong public records or sunshine law. It is important that when we put in place policies and procedures for use of body cams, that we protect the strength of the sunshine law. Why is that? We remember, as you all know, that the government is there to serve at the will of the people. The government works for us. There's very few things in life we can say that for. The Sunshine Law is one of the strongest tools to ensure that is so. By making government records generally available to the public, it reminds all of us public servants, it reminds us citizens of how we get that balance right. It is challenging. Body cams get footage that is problematic. It gets people in their worst moments, either for misbehaving police officers or for people who might be having a bad night or a bad day, engaging in conduct that is out of ordinary. It gets people in stressful situations. It gets people who are witnesses and who might not want their identity disclosed. So again, the answer is not that we say, oh, let's not use body cameras, or oh, let's just close these records. The answer is to do exactly what this body is doing, to sit, to look at the issues, to understand this is a complex tool, there are complex balances, and this committee can draft a policy that gets it right, that protects government transparency, that acknowledges privacy needs, and that allows government to continue to serve. Again, with respect to the privacy, I think we've touched on some of that with the examples. At this point, what I'd like to do is answer any questions you may have, and again, thank you for the opportunity to share our thoughts with you.
Questions from members of the committee. Alderman French.
So
I understand the nuanced approach that the ACLU takes to this subject. It is a complicated subject. So specifically with regard to the Sunshine Law, would you favor that body cam footage be completely available to the public in the same way as other footage is available?
And again, if I could, thank you for the question, Alderman. I think it's generally in line with that. The rule should be the Sunshine Law is the right law for the state of Missouri. Transparency is the right rule. So the presumption should be that government records, which a footage taken by a government agent is generally open. Within the Sunshine Law, even as it is written now, there are certain exceptions that are written in. So we would recommend that that be the general approach that is taken. The general rule is this is a government record, therefore it is covered by the Sunshine Law, and the presumption should be that it is open. But this committee can come up with specific exceptions, narrow exceptions, that would say in these instances there must be a delay, or these particular pieces of footage would be closed, or these particular pieces of footage would have an opportunity for somebody to object or to review in camera. So yes, the general rule should be government record, generally open, but an acknowledgement that there will need to be specific rules to govern specific situations.
Okay, so you talk about what we can do as a committee. I think that even if we did dare pass an ordinance, eventually the state legislature would get around to deciding this for the state. One concern that folks have is that on the one side, you have folks who are worried about police abuse and want police accountability and think cameras can help. On the other side, you now have armed government agents with cameras to go inside your house and record all kinds of things. Now, do you think that that should be available to the general public? If I call for a burglary or a domestic dispute, officers come into the house, is that footage eventually available for everybody to see?
Right. So thank you. And the two parts of your question. One, with respect to the interaction with the state, we agree with you. And as you know, the ACLU also works in Jefferson City. One of the reasons we appreciate this committee taking this hearing is because we think St. Louis can lead the way and show the example how to get it right. Unfortunately, there are some bills being proposed in Jefferson City that claim to be about body cams, but essentially are working to undermine the Sunshine Law. With respect to the examples you give, some of the procedures and proposals that have been recommended, for instance, and it does impose an extra burden on the police, but when we have new tools and technologies, that is often what happens. The situation, for example, in an interaction with an innocent bystander, in an interaction with a witness, that the responsibility is to inform the individual that footage is being there and they have an opportunity not to be recorded. Now, in the instance you gave, where there is a burglary, there's a crime in process, there's an active investigation, obviously it's not realistic in that situation. So at that point, the balance is you look at what is the footage of and who has access to it and who has a right to request it. So what we don't want is we don't want, you know, the BuzzFeed or TMZ to say to every police department in the country, give me all of your footage. But we believe the balance can be drawn where you write the specific exceptions as to what can be exempted. So for instance, if it shows footage of somebody in a state where they would not normally be seen in private, there is an ability to exempt that specific footage from general request. On the other side, you would not want to prohibit interested public servants, interested attorneys, interested individuals who are affected by the footage to be completely foreclosed.
And so what the chief of police will say is that, again, going back to an example I gave, if there is a crime, 6 officers arrive, all wearing body cams. Some footage is from the outside of the place, some footage is from inside a residence. The amount of manpower that it takes to go through all that video to decide what is available to the public, what is not. You know, what our chief of police is telling us is that it does propose a very expensive, so the body cameras alone are not the problem. It is all the data that you're collecting, how to sort the data, how to, all that. So it's a complicated situation.
Right. The good news there is that actually that balance has been struck by the Sunshine Law. So for instance, as you may know, the ACLU does a significant amount of Sunshine or public records requests annually. In some instances, as it is written currently into the Sunshine Law, If there is an extra expense needed for a governmental agency to go through those documents, to do the kind of search you're talking about, the Sunshine Law recognizes that, acknowledges that, and allows the agency to pass along certain appropriate fees. So that is an absolutely correct and reasonable concern. The Sunshine Law, we think, gets that balance right and addresses those needs.
Okay, thank you.
Okay. Alderman Vaccaro?
You know, I guess I still have issues as to when they turn them on and when they don't, but I still think my right to privacy in my house, I don't want anybody with a camera. I don't want a TV news crew busting into my house. I don't want police officers with cameras in my house. I don't believe that they need to be in my house. So I believe my right to privacy in my own home would have to far exceed anything that they would put into place. So, I mean, I would say that if they're wearing cameras, I don't want anybody with a camera in my house.
Thank you. Understood. And Alderman, thank you. It's a very important balance you're pointing out. And again, there is fortunately some existing jurisprudence in this area. For instance, quite frankly, the ACLU would prefer that there's no government surveillance. I mean, we just are generally in favor of privacy in the ways you are outlining. Again, though, given the realities of the current technological climate, given the realities of how we live, given the clamor by the public for some sort of increased policing powers, we think the best balance is looking at the tool and then putting in place the strongest protections. The difference between a public space and a private space. Clearly, in a public space, there are limited expectations of privacy. We walk around all the time. Within your home, you raise a very important point. For many years, jurisprudence at the state, local level, the state and federal level has always recognized the expectation of privacy and the unique rights we have within our own home. That being said, if there is a police call to a home for a crime in progress, what is the balance? One, let's say the police are going in on a raid where you have not requested their presence. They have the wrong address on a home, and they come in your home. My presumption is that your concern to have documented evidence, or anyone's concern to have documented evidence of police conduct in coming into the wrong home, would outweigh the concern about being filmed in a private situation. If we make a blanket rule that you never have a cam on in the home, that we could say, let's say there's a rogue police group that is busting down doors for fun. We've now lost the tools to have evidence of how they do it, why they do it, and how they conduct themselves within. So again, you raise an important point. I think the properly written procedures can get the balance rightly, but it's not never in the home.
So, I mean, so it seems to me that, and you represent the ACLU, that you believe it is okay to go in people's homes with cameras.
What we believe is that, again, the camera is a tool that can provide protections to the public and to the police. In the instance I gave of somebody going into a warrant into the wrong home, and we know these stories exist. Somebody gets the wrong address, they bust it down, they act improperly. In that instance, that documented evidence of the misconduct is very necessary to those people who have been victimized by police misaction. What we would say is, not having a blanket rule that says you can never have a body cam in the home provides a level of protection that is important to weigh against the need for privacy. Yes, in general, people in their homes have a significant right to privacy that government should always protect, and we should always limit government's ability to be in someone's home, to document what goes on in someone's home, to use what happened in someone's home. But we can, we believe, give those three protections while still not having a blanket rule that in the course of police business, you would never have body cam footage. Now, there could be a means of suppressing the footage, taking it out of a database, saying it is not subject to public record, it was a mistaken record. These are ways we can get the balance right, but it's not making a black or white rule, absolutely yes, absolutely no.
So, in the case of a Project 87 raid on a house for nuisance property, whatever, so as they're going through, now they'll be documenting everything in the house. And as a neighbor, I'll probably go ahead and get a thing, and I'll put it on Facebook and say, hey, did you realize that at the house 2 doors down, that and they found this and they found that? And you guys believe that's a good idea?
To be able to document what was on the what was going on in the home.
So if I went around and as they're collecting evidence, you guys are fine with you don't feel it's an invasion on somebody's right to privacy? Let's just say they find one joint, not even enough in the house to really have someone arrested or done anything about. So I can go in, I can get that and go, hey, did you know the neighbor down the streets had a joint in their house? And the ACLU's fine with that?
Yeah, again, I cannot stress enough. Your concerns about privacy are absolutely our concerns. So I want to be very clear. I hope nothing in my testimony has led you to believe that we do not believe that privacy is important or that we do not agree with the questions you're raising. Absolutely. The right to privacy in one's home, the right to privacy generally, the right to be protected from governmental interference and governmental surveillance is very, very important. That being said, do we then say that because of that right, we can never use a body cam, we can never have film in somebody's home? We think the answer is there is a balance. We agree with you. If you are using this tool, there must be protections that ensure that if somebody is mistakenly filmed, if somebody is filmed in a way where the footage is not helpful to protecting them against misconduct, that there need to be protections for that filming. At the same time, we do not want to undermine the strength of the Sunshine Law. So it is a very difficult balance. It's very delicate, and the concerns you raise absolutely must be factored in. We don't believe they are so great that we have to have a blanket rule that you can't use the cams.
Okay, thank you.
Alderman Cone, any questions? Not this one? Alderman Carter.
Yes, just one question. And so you may have answered this, but I think that Alderman Cone was talking to me, so I don't know. What about, what are your thoughts on citizens that request not to be recorded, like witnesses, victims of crime? What are your thoughts on that? Should there be different policies in place to exempt those?
Thank you for the question. Alderman, absolutely. Again, the law has established procedures for this. So, for example, on search warrants, they're protecting privacy and protecting the right to be safe from unreasonable search and seizure. The courts recognize that in certain circumstances, there are emergencies. You have to act quickly. But generally, police must act in a way that recognizes your right to be secure. Same thing with privacy. In a situation where officers are rushing into an exigent circumstance, if guns are drawn, if shots are fired, if there's danger to a potential victim, in those instances, there are lesser protections for turning a cam off. In a situation where you're going into a domestic dispute, in a situation where you're going in to talk to a witness, those are less exigent and allow the police officers the opportunity, and we believe they should be mandated, to inform those that they are being filmed and give them the opportunity to request that they not be filmed. You're then putting the power into the hands of the individual. If the individual believes that police are there improperly and they want a record of potential misconduct, that is available to them. If they believe that their privacy needs, their desire not to have footage available is greater, that right should be available to them as well. So the balance can be struck, and you're absolutely right. Witnesses, certain individuals should be given the right not to be filmed.
All right, one more question, I'm sorry. And so with other cities and other policies, what are some of the disciplinary actions of the officers that they have in place, just in terms of if they cut a camera off or somehow alter the filming?
Right. Thank you. Very important question. What generally the procedures put in place are, one, that these must be turned on, that failing to turn it on does subject you to discipline. Two, that the footage, if there is an incident, immediately goes to supervisors at a fairly high level of authority, and that individuals who are involved in potential misconduct, officers in potential misconduct, must write their reports prior to reviewing the footage. So in other words, the importance of the tool is that we recognize this as important documentary evidence, and again, this is for those few bad apples, the ones who step out of line, but you understand the power of this tool and you don't game the system. So yes, absolutely. Police must commit to the fact that a body cam is a body cam. We don't turn it on when we want and turn it off when we want. It is there. If you are turning it off, there is a presumption that you are involved in misconduct. And again, the law is used to those sorts of things. That's the way we've had jurisprudence for many years on searches. If you don't give somebody their rights, if you don't get a warrant for a search, They may be guilty as heck, but what the courts have said is in order for there to be power in these rules, we must have consequences for not following them. So absolutely, the camera must be turned on. There are real consequences for turning it off.
And now what, this question may not be for you. This question was probably one that could have been answered last week. But just in terms of the cameras that you see that are being used, do they automatically save to a cloud system, or are they ones that have to be taken in and downloaded the videos and the information, or do they automatically store?
Yeah, and because I don't have specific expertise on which technology they're using, I don't want to surmise. But again, there are ways to ensure that the data is appropriately available and appropriately secure. But I don't want to hazard a guess as to specifically these police departments' processes.
Thank you.
Thank you.
Alderwoman Spencer?
Thank you, Mr. Chairman, and thank you, Mr. Mittman, for being here today. Putting this together was extremely helpful. This is the first time I've taken a look at this comparison document, and for those in the audience, we have a comparison of our pilot program, our pilot program policy and the body cam coalition recommendation, a comparison by the ACLU of Missouri, Don't Shoot Coalition, and Drone Free St. Louis, that kind of outlines piece by piece areas of recommendation, and I really appreciate the efforts here. It's very clearly documented and very easy to follow, and it is appreciated by this committee. Thank you.
Thank you. And of course, I want to recognize the work that's gone into it. Obviously, we're very lucky. The partners we have on this are phenomenally talented and have a lot of knowledge in this area.
Thank you for that.
And one of the other speakers is going to speak directly to it.
Oh, is that right? Oh, okay.
Yeah. Okay, Alderwoman Green, any questions?
Thanks. Just one quick question, kind of going back to the data storage piece. So you just said, the assumption should be that the camera's always on and there's like this presumption of misconduct if it's turned off. What are best practices in dealing with all of the storage? I mean, that is a 8-hour, 10-hour, 12-hour shift. That is a lot of footage, and how long should we be keeping that for? Can you speak to that a little bit?
Absolutely. Thank you for the question. The general rule on data is that you have it available for a reasonable period of time if there is a need, but that what you want to avoid is keeping data forever and always having it available for two reasons. One, it is a cost and storage nightmare. Two, it is a potential security concern. And three, it avoids any temptation by government at some point to say, well, we have this data, let's take a look at it, not for specifics, but just to get data, general information. So the balance is you work between the police departments, security experts, and the community to find the right balance. With a general, for example, we will keep all data for 7 days, 14 days, 30 days. At that point, if there's no request, there's no incidents, it is immediately deleted. Conversely, the moment there is a criminal investigation, the moment there is a complaint of misconduct, that data immediately from all cameras is flagged, and then that is set aside for storage during the pendency of that investigation. So presumption of limited keeping time, then future deletion, and presumption of absolute protection, and set aside when there is a need or request.
Okay. Is there a standard on how long is reasonable?
There are various standards. Generally, it's in the 7 days to 30 days. And again, because this is so new, I think various police departments are experimenting with various things. I know, again, our partners at Drone Free St. Louis and the Don't Shoot Coalition. Of course, Mr. John Chasnoff has significant expertise in this area, and I think can really discuss the pros and cons of specific days or times. What we try to do is that overview of there are issues, there are balances to be had, and this body gets the information and then makes its policy determination. I think with the idea that it is a first try at it, we do our best, and then we go back and look at it and saying, did we get the balance right, or can we improve it?
Okay. And in terms of that balance, looking at specific situations where we might want to say this is redacted or this is not available for or not allowed under the Sunshine Law or released under the Sunshine Law, besides, victims of domestic violence, or are there other classes of people that we should be looking at?
Certainly you want to look at witnesses. Certainly you want to look at situations where the imposition on privacy or what the footage shows where that its public disclosure would outweigh the need for government transparency or the public right to know. So there are situations where you look at the balancing needs, the need for privacy versus the need for the public right to know and the principle of government transparency.
Okay, that's all my questions for now.
Thank you so much.
We'd like to go back to Alderman Cone.
Thank you, Jeffrey, Mr. Mittman, for being here this morning, and certainly appreciate all of the work that you all have put into this along with the coalition. And you know, last week when we had the chief here, I mentioned that, you know, I'm echoing some of the concerns of my colleagues in regards to the individual's right to privacy. I think also on Twitter someone mocked me, you know, comparing me to their grandmother because of my concerns around, you know, data security and the cloud and hacking the cloud, saying that I sounded like their grandmother for bringing that up. But it's still a concern of mine, and I think our policy is way too vague on the security of data and the distribution of data as well. So I guess my first question is, how many conversations, or, you know, what depth of conversation have you, the ACLU and the coalition, have had with the chief in regards to the policy? Because, you know, I'm still struggling whether or not this should be policy or if this should be an ordinance. And, you know, I'm kind of taking the lead from some of my colleagues here, but I want to know, you know, what conversations, if any, you've had with the chiefs, you know, in the police department, and then also the union, obviously, and, you know, your take on whether this should be, you know, law or policy.
Yeah, so first, I wanted to underscore what you said. Thank you, Alderman. We agree. The issues of data security are absolutely paramount. And we believe from the ACLU that your concerns are, if anything, not strong enough, which I know they truly are, but we agree with you. We know data gets hacked. This information is very private, and it could potentially be embarrassing for any number of reasons. So I think the concerns about how we manage the data, how much data we have, where it is, and specifically then who has access to it and how you control that access are incredibly important, and just as important as when the camera's on and how you review it. So thank you for those concerns. Those are very important. With respect to conversations with the police department, police union, I'll defer those to John Chasnoff. What I would say is that the ACLU has found in the past, when we have issues, that the mayor's office, the police department are very willing to sit down and talk to us. Sometimes we disagree strongly, but we never feel that our concerns aren't heard. As this policy and practice goes forward, we would anticipate we'd be having some of those conversations, and to the extent they want to do those in private, we want to keep you informed, we'd welcome that opportunity.
Thank you.
I know you had to get out of here, so we do appreciate your presentation to us today.
Thank you so much, very much.
All right, thank you. Next, we will have Kayla Reed, who will be discussing the democratic process and body cams. Then after that, John Chasnoff will discuss their specific recommendations. And then Rachel Kent will do the comparison between the city's policy and their recommendations. So, Kayla Reed.
Good morning, excuse me, and thank you all for taking this time to hear community organizations on the issue of body cameras. So I'll be speaking about the lack, am I too loud? Sorry. I'll be speaking about the lack of inclusion that's existed with the body camera pilot program. So since the city has been given local control of the St. Louis Metro PD, the ways in which processes are created and policy is implemented has not been very clear to the public. In order to build trust between the community and the police department, there needs to be a continued effort to be both accountable and transparent. And police leadership seems to have a tendency to make decisions behind closed doors. As we continue to highlight recommendations for body cameras, we must recognize that it is not the first time that St. Louis police have implemented policy without public input or support. In a previous hearing called by the Public Safety Committee, Chief Dotson stated that he changed the use of force standards within the police department. When asked how policies are changed throughout the department, he stated that he can make those changes unilaterally. Another example of non-inclusive policing, or policy making rather, is the money that went toward the Real-Time Intelligence Center. Most times when a policy is introduced by the chief, the documents are not accessible to the public, and the majority of the time we only know about it because of a press conference or an article. The example I will give for this is the body camera pilot program was in the Post-Dispatch. And while we are thankful that we have that, Channel 5 and the Post-Dispatch are not platforms to have meaningful conversations. At 2 different points since October, the coalition that works on body cameras have submitted sunshine requests asking for information on the pilot program. The first request returned very little information. The second request had to be sent because the dates Dawson told the public through media were not accurate, but it did return a lot more information, but it took an additional 2 months. However, the issue with this process is access. It costs to get this information through the sunshine request. In this case, it costs the different organizations and coalition over $200. And we argue that there should have been input from the beginning. Dawson stated last week that this pilot policy came from 30 different cities. He took best practices. And so we're arguing that this transplant of ideas doesn't accurately represent St. Louis, and there needs to be an inclusion in a democratic process to reflect what this community wants. And poor people who are guaranteed to be most impacted by this policy cannot afford to pay for sunshine requests to receive information. In order for democracy to work properly, there must be space created for input at every stage of development. There must be meaningful dialogue between elected officials, community members, and the police. Democracy cannot be private. It cannot just be organizations who have the capacity to pay for these requests. To ensure a democratic process, it is only right that the Board of Aldermen introduce and pass legislation around body cameras. The legislative branch is the closest to the people. You have the means to create space for dialogue and actually hear from community members. If this city is going to spend the kind of money it requires to launch the program, we need to take time to hear the concerns and the ideas of people and invested organizations. Dawson has stated that the next phase is public input. He said that last week. And while we think that that is a good start, we are concerned what that process looks like. As we continue to fight for access, it is important to understand how some communities are not trusting of the police and are more likely to enter space and contribute when it's someone that they voted for. I'm less likely to go to a meeting sponsored by the police, more likely to come down here on a Thursday morning to voice my concerns, or a ward meeting. Some people have stated that the issue with passing an ordinance through the Board of Aldermen is the amount of work it takes to make changes, but we agree that this is the most stable process. It should not be the police alone who listen or ignore input when making decisions. If the chief of police can make and change policy at their will, then a shift in leadership could completely change the program. Dawson also stated that he was concerned about Jeff City passing a law around body cameras that would undermine any policy we passed here in St. Louis. Our response to that is that St. Louis has led the way on many issues like minimum wage, and body cameras can be the same. Perhaps our ordinance, once passed by the Board of Aldermen, can serve as a pilot program for the entire state. We cannot fear change and use it as a reason to avoid democracy. We have a responsibility to lead the state in a more progressive direction, and we have a responsibility to ensure democracy is always the priority and that people are included in the process. Our chief should be in support of that, and body cameras should be an issue that is led by those we elect and the policymakers on our behalf. And that is my testimony. Thank you.
I would like to hold off on questions till we get the other 2 speakers, and then we can ask them all together. So let's now bring up John Chasnoff.
Hi, thank you all. I appreciate being here today. And what I'm going to try to do is lay out our recommendations in not great specificity, but some specificity, so we can get a little deeper into some of the questions that the ACLU raised earlier on, and hopefully answer some of your questions about where we're trying to strike the balance on a lot of these issues. So the sheet that you have in front of you has down the left-hand column what our recommendations are, and in yellow are some of the ones that we've highlighted that I'm going to try to hit on today, though I'm not going to try to be comprehensive, but hit on, I think, the major points. There are really several categories when looking at this, and questions fall into some groupings. So one of the important questions is, when are the cameras turned on, and when are they turned off? The other question is retention of data. Also, who has access to that data and how is it appropriately used after it's collected? Then there are the questions around the Sunshine Law that some of you have been raising, and I want to go into a little more depth on that. And finally, the question of discipline and enforcement for officers who don't follow the policy. So that's what I'm going to try to hit the highlights of those today. The first question is, when are the cameras turned on and when are they turned off? A lot of people in the activist police accountability movement would have as their first reaction that the cameras just ought to be on all the time. And that's completely impractical for the reasons that Alderwoman Green pointed out. It just would amount to huge amounts of data that really couldn't be stored. Actually, the battery life in most of the cameras don't have the capacity even to run an 8-hour shift. So you have to have some capacity for the officers to turn the cameras on and off, and that gets into a lot of gray areas. Where we come down is that whenever the officer is interacting with the public, the camera ought to be on. So when they're sitting in their car talking about what they had for breakfast and, you know, family issues amongst, you know, each other in their police car, the camera would not be turned on. But when you start to engage in an interaction with the public, you never know how those are going to go, so that's the time the camera ought to be on. And we also believe, the same as the ACLU, that there ought to be notification. I know the street cameras in the city all have flashing lights and are very clearly identified, and we believe that for privacy reasons, people ought to know when they're being recorded, and so there ought to be notification. Again, we build in some exceptions. Those are, you know, when practicable, you know, when it's safe, you know, in a exigent circumstance, you might not be able to tell somebody right away they're being filmed, but as soon as you can, you ought to make that known. We do provide, though, for some exceptions to that general policy that the cameras are on when you're interacting with the public. So the question was raised already, and we come down on the side of turning the camera, or giving certain people discretion to say to the officer that I want the camera turned off. So a crime victim ought to have that right to say, I'm not comfortable with the camera being turned on. And especially in child abuse cases, sexual assault cases, we don't want to be rushing in and to people's private trauma and not giving them the option to have the camera turned off. Also, crime witnesses may not feel comfortable coming forward if they feel like they're being recorded. They ought to have the right to turn the camera off. And finally, neighborhood folks who want to report some activity in their neighborhood, again, they might not feel comfortable feeling that they're being recorded, and that might end up on the internet, which might put them in some danger from outlaws in the neighborhood who, you know, don't like their coming forward to the police, and so they ought to have the right to turn the cameras off. And we think if you don't provide that discretion on the part of those folks, that it's going to inhibit the police ability to collect information that they need. We do think, however, though, that whenever the camera is turned off, that the reason for it being turned off ought to be recorded. So there's clear accountability. We're not wondering later on whether this was an appropriate decision by the officer to turn the camera off. So he ought to get it either on the camera that somebody has asked him to turn it off, or you know, if for some reason he can't record it visually, he ought to have a slip of paper that records why the decision is being made to turn the camera off. That way we have the appropriate accountability later on. We also think, though, besides that discretion on the part of subjects, that there ought to be certain things that are just prohibited when the cameras can't be turned on. And we would include that recordings of confidential informers, undercover officers, places where there's reasonable expectation of privacy, strip searches, other agency personnel during routine non-enforcement situations. So again, that situation of when you're in the car together, or even if you might be out in public, no reason to be recording other agency personnel when they're not engaged in law enforcement activities. And finally, questions that have to do with specific strategy and police tactics that they feel need to be kept confidential. That there are already provisions in the Sunshine Law to redact that kind of information, but we would turn the cameras off, for instance, in a strategy meeting about particular police tactics. So then we get into the question of retention and how the data is stored. We think that there ought to be some distance or firewall between the police and access to the data. I think the presumption now is that the police will have their own server and have their own access to the information. But we would prefer to have some sort of neutral body who's holding that information. We suggest a non-law enforcement government agency. We say non-law enforcement, again, to build in that distance, but we say government agency because government agencies are subject to the Bill of Rights, and we think we have better protections if we have a government agency holding that material. But we think, for instance, that police officers ought to have some kind of reason to go into the database and access information, such as if they have a reasonable suspicion that a crime has been committed, then it makes sense for them to go and get the evidence that they need for that particular case. But if you have a neutral person that they need to go to and show their reasonable suspicion, then you have a little bit of a safety feature built in for who's accessing this kind of information. The other thing that we think is really important is that there is an appropriate flagging system so that data is categorized appropriately and not so that useful information isn't lost. So we have certain things that we think should be automatically flagged for greater retention, and those would include any use of force above a verbal command, detention for more than 5 minutes, a search that's greater than a pat-down, and an arrest or whenever there has been a filed complaint. And the reason we include some of those lower uses of force in the automatic flagging is that those are situations where there is a possibility or a likelihood that somebody might be filing a complaint, and we don't want to see the data lost or destroyed before a citizen has the time to get their act together and make a decision and come in and file a complaint. So we want that data held until a person has a reasonable time to come in and capture the data that they think they need to make their complaint. Then we think that there are certain types of data that the police officer ought to be able to request that it be flagged for further retention, things that have evidentiary value for training purposes, request by any of the subjects who are subject to the video. They ought to have the right to have the data flagged for further use, and for academic research. So some of this information is incredibly useful for deciding things like, I know in the Kajim Powell case, the question of the 21-foot rule came up and whether that was an appropriate rule. Well, if we had body cameras of police officers' reaction times in various situations, if we had that data, it would be very interesting research to see whether the 21-foot rule is appropriate and when, and we ought to be able to have some way of making this data available to researchers to improve our knowledge and our capabilities on this front. Mr. Mittman mentioned the question of when the officer gets to review the footage, and we come down on the same side as the ACLU, saying that the officers ought to file their reports, their initial reports, and give any initial interviews before they watch the video, and that way we capture the information that they've directly perceived. So I wanted to spend a little bit of time on the question of the Sunshine Law because I think it's a really important area here. In general, we come down on the side of recording more often than not, but protecting privacy interests on the back end through redaction of the materials. And that's something I don't think the board has talked about too much, so I wanted to go into a little bit of depth on that. A lot of agencies around the country classify the body camera data as investigative reports. And an investigative report is closed until the investigation's finished, and then it's open. It's also a fact of our Missouri Sunshine Law that if something is an investigative report, there's no real possibility of doing much redaction for privacy purposes after the fact. In our view, these reports are really incident reports. That fits most closely with the definition of an incident report in the Sunshine Law language. And incident reports, I could get you all the court case that delves into this in some detail, but incident reports allow for redaction of materials after the fact in much greater detail. So the basics of an incident report are always open, like the name of the person, where the event happened, and some of the basic data. But it's been ruled that license plates, for instance, can be redacted. Social security numbers can be redacted from incident reports to protect privacy. And so we think, even given the current law in Missouri, without changes on the state level, that if we classify these as incident reports, we can do the appropriate redaction of the video footage. And that involves fuzzing out faces, changing the auditory track so that voices are distorted, or in Alderman Vaccaro's example, if officers are moving around a home, items in the home that are basically personal and not pertinent to the information we need could be fuzzed out through redaction. And in terms of cost, that raises a big issue, but there are new programs that do a lot of this redacting automatically. San Francisco, for instance, just puts all of its body camera footage online, but sends it through an automatic redaction process first. So I don't know if we're there yet completely, but I think we're moving in the direction of finding cheaper ways to do the redaction. So the last point I wanted to touch on is enforcement. I think it was Alderman Carter who raised that question. What we recommend is that there be, for the first incident where a camera was not turned on appropriately, that there be appropriate discipline, and let the department decide what that is, especially in the excuse me, in the early parts of a program. Something in my throat, sorry. In the early parts of a program, when officers are being trained, they're going to make mistakes, they're going to forget to turn it on, and the discipline might not be as heavy for the first few months when they're learning the equipment. But for a second offense, we think that there ought to be a suspension without pay, and if there's a pattern of offenses, that there ought to be up to and including termination for a pattern of offenses. And the other important area that we get into, appreciate it. This will do it. The other thing that we recommend is that there be a presumption in court or in a misconduct investigation that if the camera was inappropriately turned off, that the presumption be against the officer in making a decision. And we think that would go a long way towards helping officers remember to turn it on. So if they go into court and the footage would have been really helpful to the defendant, but we don't have the footage because the camera was turned off, then the presumption would be in favor of the defendant in a case like that. Or thanks, you all are looking out for me. I appreciate it. Thanks. So our next speaker is going to go into a little more depth into why we made some of the decisions we did, and also where we see the pilot program lacking. But I think that lays out for you some of the basics, and after our last speaker, we can get into some questions. Thank you.
I do have a couple I do want to ask while still up there.
You what now?
I have a couple questions I'd like to ask.
I'd ask if we do hold the questions to the last person.
We're thinking that they might be answered by the next speaker, but if they're not, I'll be happy to answer them after she's done.
Okay.
Thank you all very much.
Thank you. Let's next bring up Rachel Kent.
John is significantly taller than I am. Oh, can you hear me okay? Oh, sorry. My name is Rachel Kent. I'm the Executive Director of the Peace Economy Project, and I'm also a member of Drone Free St. Louis and the Don't Shoot Coalition. As you've heard my colleagues testify, body cameras are a very complex, nuanced issue. Very few answers are easy. There are lots of hard questions, and a lot of times I'm sure you are not, as we can see, are not necessarily satisfied with all the answers. So I'll do my best to compare what the Body Camera Coalition has recommended. And this was created with public input. We had a couple of different town halls, and we've revised our recommendations based on the feedback that we've gotten. And then the middle column, the pilot program policy, which was written by Police Chief Sam Dotson, and then some of our critiques and some of the differences and recommendations for the future as St. Louis moves forward and discusses body cameras further. So as John mentioned, when the body cameras are turned on and when they're turned off is a pretty basic premise, and there needs to be a very clear-cut rule. The public says that we want more recordings and we can worry about privacy afterwards. Police Chief Sam Dotson, in his testimony last week, agreed about the same thing. The pilot program has pretty much very vague policies. It allows for officer discretions. Different officers are going to use different criteria, and allowing officers to use discretion doesn't assure that all incidents that should be recorded would be recorded. As we are all very aware, incidents can go unexpectedly wrong very quickly. There might not be time to turn the camera on. Assuring that the camera is on whenever an officer is interacting with the public assures that any incident and video that should be recorded will be recorded. So it's pretty clear cut, the camera should be on. The next highlight that John mentioned that I'm going to talk about a bit more is notification of whether or not the subject is being recorded. The pilot program says that officers are strongly encouraged to notify the public that they're being recorded, but that's kind of vague. What does strongly encouraged mean? And we think it's very important. Behavior on both sides of the public and the police are going to be better if everybody knows that's being recorded. We also believe it's in the legal interest of the police department that the officers tell the public that they're being recorded. It just lets everybody know what the situation is, and if there's any reasonable, if reasonable expectation gets fuzzy or unclear, everybody was knowing that they were going to be recorded and that the video could potentially be reviewed. The other highlight that I want to talk about is on the second page, a little middle row, about which videos are prohibited. So some of the policies between our recommendations and the pilot program is similar. They're not completely and totally different, but one of the key differences that I want to bring up was the non-recording of administrative investigations. And in case anybody does not know, administrative investigations usually refer to when a department policy has been violated, but not necessarily the law. This is especially important with the recent establishment of Civilian Oversight Board, which might want to investigate or examine these administrative investigations. If these are prohibited from being recorded, as they currently are in the pilot program, then interviews might not be recorded or other aspects of the investigation. This is crucial information that the Civilian Oversight Board might need to fulfill its responsibilities and obligations, and therefore we should ensure that there is a clear definition as to what an administrative investigation is and why they would not be recorded. So this definitely is something that the Board of Aldermen should be concerned about as they move forward and discuss body cameras further. And the other question, and some of you on the board have already asked about retention data. As John mentioned, we have come down on the side that there needs to be a neutral third party holding all the retention, preferably a government agency. As John mentioned, it's subject to the Bill of Rights. We need somebody who is neutral. We need somebody who can vet access and vet requests to make sure that officers aren't just asking for videos and just getting them. They're ensuring that officers have reasonable expectations and a reasonable right to see the videos that are being requested. And government agencies are held more accountable to the public, so we can ensure that the videos are getting out when they need to be getting out. On the third page, there are a couple of boxes that talk about flagging the videos, which again were mentioned. But part of this, why we want to ensure that there's a strong flagging policy, and the pilot program right now doesn't really have a policy, is it is part of a cost concern. As it's mentioned, it costs a lot of money to hold data for a long amount of time. Right now, the pilot program mentions retention categories and says the officer should put the video in the appropriate retention category. Well, that's pretty discretionary, but it also doesn't list in the pilot program what the retention categories are. And these need to be clear. And part of it is that it helps maintain privacy if we get rid of unnecessary videos, so we're not holding on to videos that we don't need for a very long time. It also ensures that we're using our money effectively and that we're paying to store the videos and the data that should be stored and should be saved. At the bottom of that same page, you talk about access. Right now, the pilot program says that officers with permission can access the videos, but it doesn't say what the criteria for accessing is. It doesn't say how they get it or when they get it or why they get it, and it also has no rules saying who grants officers access. So it's a pretty vague policy and definitely needs to be fleshed out, and there needs to be clear rules as to who's giving the permission and making sure that officers are actually accessing the video for valid reasons. And the other part that we would like to highlight is that the pilot program doesn't mention compliance for random audits, and this is the best practice to be able to have random audits to ensure that the policies are being followed, that officers are, videoing when they should, and it also allows to ensure that random audits are not the direct line of command is reviewing and auditing their officers. You don't want your supervisor necessarily, he doesn't like you for whatever reason and being able to view your videos for one of those gotcha moments. And so that prevents that and allows more objective, reasonable viewing of the videos. And immediately below that one is writing the incident reports. So John mentioned this, but I also want to go into it. So right now in the middle column, it says that officers should review the data before writing their reports. This is a definite no. Officers should not be viewing the videos before writing their reports. We all know that memory can be very fluid and it can change, and the concern is that officers will see a video and it will fill in the blanks or alter their memories, and it won't be a true, accurate representation of how the officer perceived the situation. Right now, the law is based on the officer's perception. Did an officer reasonably perceive that he was in danger? Did that subject, was he reasonably, endangering other public members or something like that? But having the officer write the incident report is ensuring that it's accurately saying how he perceived the incident to happen. And you also have that second information of the video. Neither one is perfect, but both of them are different. And so that helps, have accountability for incidents when we're reviewing them. So this is something that the pilot program definitely needs to change, and we hope that the Board of Aldermen will keep in mind as they go forward. And then there were a few other highlights on the last page, but John did a pretty good job of going over them. The last thing that I do want to highlight is right now the policies are subject to disciplinary action. Again, that's very vague. There's not a good definition. We need to make sure that going forward there's a clear rule line of what happens and an officer doesn't follow the policies that he's setting up. So those are just the highlights. I know John said this, but I do want to emphasize that this is by no means a comprehensive summary of all the points. This is a very complex issue, and the testimony that Police Chief Dawson gave last week and our testimony today are great first steps. But we do hope that as the pilot program finishes up this month and all the data is analyzed and gathered, that the board will very much review it and then take these into account. We hope that you remain engaged with body cameras. We hope that you keep the public informed and involved. We hope that you keep the public involved and engaged. And thank you again for holding this hearing. We appreciate the opportunity to talk to you.
Thank you. Alderman Vaccaro, you still have some questions?
I have questions. Whenever you're ready, I don't care.
Okay. We're at that place now to, did you?
If I do that,
Mm-hmm.
I have questions.
We'll bring all three of them up here. Okay, Alderman Vaccaro.
Okay, I'm going to try to remember. John, one of the things you brought up was if somebody says, I don't want to be filmed, but realize that there's a 30-second buffer where this thing films, so you could be doing whatever you want to do. It's not going to pick that up for a full 30 seconds, and we can time it out. It's quite a while. You talking about?
I thought there was some confusion about that last week, and my understanding of what that buffer means is a little different than I think what was generally understood last week. So,
It films, but you get no sound for full 30 seconds. So I could film you completely in your underwear, trying to tell me, turn the camera off for 30 seconds. It's filming you, and all we see is this.
I think that's a misunderstanding, so I wanted to see if I could clear that up. So my understanding is that the camera is constantly looping, so it's not turned on, it's not recording, but in the background, it's recording a 30-second loop. And then when the officer hits the on button, that 30 seconds is saved. So previously to that, it was never being saved, it was just a loop that was erasing itself. When he hits the button, then it saves 30 seconds before he started the button.
I understand that.
And that's
So-
the part that doesn't have the audio.
Right, and
So
there's
he
no
could
audio.
be, when he comes up to your house and turns the camera on, you're going to see 30 seconds of him walking up to the house and all that, but when he turned the camera on and he's interacting with you, that's going to have the full audio and video.
Depending on when he turns it on, whether he turns it on walking up, or does he turn it on when he first knocks? When does that turn
Right.
on?
So one of the things we built into the policy is that when it's a call for service, you ought to turn the camera on before you get there. And the reason for that was, I know that the chief took a lot of his policy from San Diego, and San Diego had an incident that caused them to change their policy. An officer drove up to a call for service and was suddenly confronted by somebody coming at him with what he thought was a gun, and he jumped out of his car, shot the guy, and it wasn't on camera. And so San Diego changed its policy that the camera ought to be turned on as you approach a call for service. And we'd recommend that too, so you get past that 30-second buffer that way and make sure the camera's on before some exigent circumstance happens.
So, and I understand what we're going at are gunshots, but you're also going to have traffic violations, traffic stops, simple traffic stop, where, again, that 30 seconds is going to be in there with no, so when they walk up to the car, it's not going to take them 30 seconds, but so they get out of the car, they turn the camera on, they walk up, and now there's,
So the 30 seconds would have been him sitting in his car.
so what's he- so
And then
he'll
when he
sit-
got out of his car and turned it on, then the audio comes on as well, and the 30 seconds before that is the buffer period.
So they would sit in their car for roughly 30 seconds? Because again, if I was a police officer, I would think, well, when I get out of the car, I'll turn the camera on as I walk up to a vehicle, not sit in my car and say, well, I want to wait a full 30 seconds before I walk up to a car.
No, he would turn it, so I'm agreeing with you. I think that he would turn it on when he gets out of the car. And then what we would see is 30 seconds of him sitting in the car without audio. That was before he turned it on. And then as soon as he turns it on, then you have the complete audio and video from the moment he turned it on forward.
And maybe I have a misunderstanding, I'll have to check that. I think I have a little bit misunderstanding that. The other thing has to do with the redaction. If you start allowing them to edit a tape in any way, shape, or form, the credibility of any recording becomes useless. Then I would start to question, well, if they were able to go in and they're able to edit it, then how do I know they didn't edit out something that, I would have questions about that.
That's one of the reasons why we are recommending this third party, this non-law enforcement government agency, that they would be doing the redacting, not the police officers who have an interest. And I think I would agree that the original footage, unaltered, ought to be maintained and kept so that there could be audits or whatever to make sure that the redaction is appropriate.
Well, then, I guess my other last concern is in court, if the police officer is not allowed to review the tape or write a report based off of, because whatever he sees or whatever happens at the minute, there could be what he perceived and whatever, and I'm not talking about gunshots, I'm talking about normal arrest. He writes his report, and it differs. Every attorney is going to say, well, you said in your report, but yet here on this it shows something a little different. I think it's going to, I think it, because again, you're asking them to write a report an hour or two after they witness or do whatever a crime, yet they don't have the advantage of going back to say, well, I thought I saw this, but I just want to make double sure. So they write a report based off of what they thought they saw, or how they perceived they saw. I'm not talking about gunshots now. I'm talking about just simple home burglaries. You know, I saw the suspect going out of the window on the north side of the house, and he was carrying a TV set. And when the attorneys reviewed the tape, well, it was a computer, and it was the south side of the house. So what did you really see? Well, you know, so I'm just saying it's going to, you know, you start getting into, and again, I understand what the cameras are about. I understand about the shootings. I understand about that. But when you start saying that we don't want them to at least make sure that they're, what they think they saw and what they are actually seeing in those cases. And again, if I'm an attorney, I love this, because I'm going to be in there defending all my guys going, well, he didn't have a television, so how do you know he had, you know? So I guess that's my concerns about not allowing them to at least, you know, do a report based off of what, you know, what they saw and what actually happened. Because if all we're trying to do is get to the actual truth, why not let them look at the tape and write a report off of what actually took place? The tape would also verify it.
So here's my reaction to that. Our full recommendation is that the officer fill out the incident report, and then he sit down with his supervisor and they watch the video, and then they can explain any discrepancies. But we think that that's why we have courts and juries. So, you know, we take all the information that can be gathered and we take it to a court situation, and we allow a jury of our peers to decide, weigh the evidence, and make a decision. So if there are discrepancies between the officer and the video that are minor or explainable, then I think a jury would, you know, disregard those. If they're major and not explainable, then they might put more weight on the video than they do on the incident report. But I think that's what our criminal justice system is designed to do.
I just expressing why I would have concerns about, you know, and again, I'm not opposed to the body camera. I'd like to know what all the rules are. Obviously, you know, I'm very concerned about privacy. I'm very concerned about my privacy. And also I'm concerned about, again, normal, just simple home invasions that, you know, the police witness, you know.
I'd also like to say that I think that there's something to be said about how we frame the police needing to watch the video before they make a report in comparison to the civilian, right? So if I'm pulled over and something happens, I'm not able to watch that camera before I make a report or before I tell my account of the story. And so what's told in court on my behalf is completely different than what is shown on the camera. And so oftentimes what it does is keep the video neutral to say that a person isn't rewriting the story based on what the public will see and not what their opinion of what happened. Because there are things that videos cannot explain, or there are things that the report is giving that's not in the video. And I think that we have to allow the justice system to work and to be given both of those testimonies, because the public, then we're kind of favoring the police over a regular person's testimony, and I think that isn't.
No, because I still feel that the video will back up whatever's written. And
on the police side, right? Because they watched it. But on my side, I have not watched it.
You'll be able to watch it because somebody will put it on Facebook, and there'll be like 20,000 views of it. So
I don't know if that's how body camera works more so than civilian film works,
but I'll sunshine it. Let's just say you get pulled over, and I decide I'm going to start sunshining all these things just for fun, and then I'll take all the ones I think are more hilarious than that.
Well, with how long it took us to get this sunshine request, I think that I probably would have written my complaint before the video was released to the public. So I understand what you're saying. I'm just saying.
I just have so much concerns about my rights. I don't drink, but maybe I'll take it up one of these days. And if I get pulled over and I'm drunk and somebody, you know, and I'm being really silly and somebody decides they're going to put it on Facebook, of course it becomes the hit of the week. And I go to court and I try to say, well, I was on some medication, except for, you know, by then, even a jury's been somewhat tainted because it says, you know, I'm just telling you, there's a lot of reasons that.
I don't have a response for that scenario.
There's no, I mean, and I'm not asking for a response. I'm just saying, you know, I'm diabetic. Maybe I'm having a diabetic issue, but on Facebook it comes out that I'm drunk and they decide to post it all over Facebook. I still am very concerned about my rights and these things being extremely sunshineable.
And Alderman, that's where we do make some distinctions there. It's hard to go into all the details in short testimony, but we do make some distinctions around unflagged footage and or unredacted footage and redacted footage. So we think that redacted footage should be open. And so what would go on Facebook is a redacted version with your face blurred out. And only in very extreme circumstances do we think that unredacted footage should be open under every circumstance. So those are legitimate questions. We've tried to answer them as best we can, and maybe as you all consider, you know, you can build on these policies, and because there's always a different situation imaginable that adds to our understanding and how we write the policies, and so we'll try to cover whatever we can. But I think we do cover that with the redaction process.
Okay. Not quite going in seniority order. Alderwoman Spencer mentioned that she needs to run out real quick, so I'll allow her the opportunity to ask her questions right now.
Thank you, Mr. Chairman. So I did have a couple of questions. I kind of go through them one by one. The policy of not recording encounters with the general public always turned on. One of the concerns I have would be with, you mentioned informants, but you know, in some cases going to community meetings, coming out and maybe just interacting in a positive way with police, or excuse me, with residents on the street. I think, you know, maybe we should allow for some space that could be just purely interactional. Or maybe, and I'm actually just asking for your input here rather than providing my thoughts, but exploring that just a bit. I feel like there might be some space for that. Is that,
So you're saying in regards to like a response call,
well,
versus
in response to having them on all the time, in an effort to maybe, I guess if I'm a member of the public and I'm walking down the street and, I mean, community meetings, for example. I think the chief was speaking on wanting to allow for space where folks, we wouldn't have to turn them on as often as every single interaction. But we can, why don't we go ahead and table that, because it sounds like maybe, I mean, I have to agree with John and the panel here and say that the general, in general, we want to be in favor of having them on more often than not, and providing the protections that Alderman Vaquero were talking about, privacy protections on the back end. And so I really, really appreciate all of these, you know, outlining. And I guess what I kind of will go to, my next line of questioning was around Caleb, Ms. Reed brought up a really good point about, you know, trust in police not knowing about this policy, other policies, even this initiative until we read about it in the Post-Dispatch. And I have to agree with her on this. I personally, as an alderman, did not really have any further information than the general public did. And I think it would be in our best interest as a legislative body to request that when we have new policing policies, that the chief let the public know, let us know, and be a little, you know, maybe move toward being more open with everyone on these things. You know, something we discovered in Subcommittee Chairman French's subcommittee on the use of force policy was that these use of force policy documents are not as accessible to the general public as as, to make our job a little more difficult and the job of some of our folks, the folks coming to help us. And that's an important piece of the policy, is making it accessible to the public and allowing for that public dialogue. I think the work here that these groups have done is phenomenal. It's very, very helpful. And I would like to request of the chairman respectfully that we ask the chief to review these documents and maybe even report back to us and provide us with some,
Feedback.
response to this. And so thank you for your efforts. The questions I had were sort of granular, and so I think I'll just leave them and let that be. So thank you again.
Is there a more full document that you have with the details or?
So we've been going through repeated revisions, and so we don't have prepared yet a formal document. As we're putting it together, we'd be glad to provide you with more detailed information, but at this point, this is our best encapsulation of where we're at.
I think that what we're hearing is that some members would like to see whenever you have that, with that document.
Yes.
Okay. Alderman Cone.
Thank you, Mr. Chair. Again, I just want to commend the work that you all have put into this. It's great to be able to see your recommendations side by side with the policy. The questions that I have for you, just some clarity on the retention piece. When you're saying retention by a government, a non-law enforcement government agency, so you're opposed to a third party outside of the government having the retention of this data, which I agree. I just the privatization of government services is a great concern to me. So, and also the control and accessibility of that data once it's outside of the realm of government is of concern as well. So have you all had the opportunity, I asked this of Mr. Mittman, have you all had the opportunity to sit down with the police chief and discuss where there's differences between your recommendations and the policy, and how have those conversations gone if you've had them?
We're just starting that process, so it wasn't that long ago that we were able to get the pilot program policy. But we have had an initial conversation with the chief where he was very open to that discussion, and we talked about coming up with mutual recommendations for Jeff City in terms of sunshine law changes or whatever. And we also have had some initial contact with the Ethical Society of Police, who expressed their support for body cameras and some concerns around privacy. And so we're planning on deepening those relationships as well, but so far we're just in the initial reach out stages.
Okay. And have you all had any contact with the POA on the matter at all?
We haven't, no.
Okay, all right, I just have to ask the question.
Yeah.
So thank you for all of your work. It means a lot.
Alderman Carter.
Thank you, Mr. Chairman. Okay, so Rachel, I had a question for you. I think it was more so about, you spoke on coordinating the COB review committee with the body cam information. So are you suggesting that we do interview witnesses and victims on the body cam, so then later on that can be reviewed if it's an incident with if it's an incident with like an officer, so the COB committee would be able to use that information?
That's a good question, and I might have to have John help me out a little bit here.
Okay.
It is prohibited that confidential informers be recorded. However, in terms of administrative investigations specifically, there doesn't seem to be clear policy as to whether or not interviews with witnesses would be recorded. But if they were, the Civilian Oversight Board would maybe want that or need that information to ensure that there was proper protocols followed by police officers. So it's a way to ensure that there's police accountability for their actions.
Right, so are other John and Kayla, this question may be for you guys. So are other cities that have citizen oversight boards, do they sunshine or are they privy to the information that's taken from body cams or no?
Yes, I think I can answer.
You go to the
So, yeah, first I'd like to agree with what Rachel said, that we get a lot of complaints that people went to internal affairs with a complaint and that they didn't feel they were properly interviewed, or that the record of the interview didn't reflect all their answers. And I know that the internal affairs now videotapes interviews that are held inside the police headquarters, and I think that's a great step forward. So when they're out in the field, I think the body cameras could take that place when they're out in the field following up with interviewees, and I think that would be an important record to keep for a record of the investigation. Other departments, the other civilian oversight boards, it's a huge spectrum of what they have access to, but in general, most of the boards at a minimum have access to the same information that internal affairs had. So they're not just reviewing some summary of an investigation, they're reviewing all the documents of an investigation, and that includes the body cams.
Okay. That's all the questions I have for now. Yeah.
Alderwoman Green.
I don't think I have any more questions at this time.
Alderman Carter, you had another.
I had one more. Rachel, you spoke on, I guess, audits.
Mm-hmm.
And so how would that go, just in terms of an audit of the body cam, the police body cam system? But were you speaking on the system or just the process? I was confused.
Sorry, I think more of just the process. So we
Okay.
believe, and there are studies that show across other cities and other departments, that there are random compliance audits, and that it's very important that people who are in the direct chain of command are not the ones conducting the audits in case they have personal beefs for their supervisees for whatever reason. The current pilot program doesn't allow for any kind of random compliance audits, and we think that's really important that St. Louis has that instigated so that there can be random checks on the police officers to make sure that the videos are on, to make sure that proper protocol is fulfilled, and that it's being done by a neutral third party.
Okay. All right. Thank you.
Alderwoman Green, did you say you had any questions?
No,
You did not. Okay. Alderman French?
No question.
Then I believe that completes us for today. We do appreciate your coming. If there are any other documents that you feel would help the committee, feel certainly free to get that to us. Once you've compiled a more complete document, certainly we'd like to see that as well. Okay. So we want to, I think at some point, the committee itself may have a discussion around its thoughts and recommendations to get to the chief. And so your input has been very helpful and will be helpful, I believe, towards that discussion. Okay, thank you. That basically completes our agenda for today. We have no other items on the agenda, then our meeting is adjourned. Thank you.